Hey guys, welcome back to another new video. You are welcomed by 7-Week Law Guru channel. So today our topic is Qui Facit per Alium Facit per se. This is a legal maxim under Law of Torts under the chapter of Vicarious Liability. I have taught you this legal maxim in Hindi also. If you have not seen that video or watched that video, please go watch it, and if you have any doubt in that video, in Hindi video, please do comment. I will give that video link in the I button. So let's start our video. And before starting our video, if you have not subscribed my channel, please do subscribe so that you will all get the Law of Torts related videos. So let's start our video. So what's the meaning of the legal maxim Qui Facit per Alium Facit per se? This is a very important legal maxim under the chapter of Vicarious Liability. This particular legal maxim Qui Facit per Alium Facit per se may come for short notes in the question paper. So I am teaching you this in brief so that you can write something easily. So what is the meaning of this legal maxim? Let me read first, then I will explain. It means he who acts through another is deemed in law as doing it himself. What is the meaning of this particular line? The meaning of this particular line is that if someone appoints someone, supposedly A is a master and B is his servant. So A appointed B to do certain work or task in his house. Okay, if B doesn't do that particular job that A has asked to do him or her, then who will be held liable? The master A. He will be held liable because in this particular maxim it is said that he who acts through another is deemed in law. It is deemed in law that if someone who has appointed someone else to do certain amount of work and he or she is not doing that particular work, then that particular person, in the case of master and servant that I give example, in that case servant will be also responsible or held liable as well as the master, as in case of general rule. What was the general rule? When I was teaching you vicarious liability, the meaning of vicarious liability, then I had taught you that the general rule was that if someone has committed a wrong, then he will only be liable for that particular wrong and no one else. So in this case also the servant will be liable as well as the master. Master, as in case he has done that particular act or has omitted to do that particular act himself. The master's responsibility for the servant's act had also its origin in this principle. What is the reasoning behind this principle? The reasoning is that a person who puts another in his place to do a class of acts in his absence necessarily leaves to determine according to the circumstances that arise when act of that class is to be done and trust him for the manner in which it is done. According to this maxim, if in the nature of things the master is obliged to perform duties by employing servants, if master is obliged, he is being obliged that he has to employ servants to do a particular work or perform certain duties, then he is only responsible for their act and no one else, as in the same way that he is responsible for his own acts. In simpler sense, if you have to write the meaning of this legal maxim in a simple understandable line or sentence, you will have to write that if someone has appointed someone else to do a particular work and if he or she has omitted or had done that particular work or had committed wrong, then who will be held liable, the servant will be held liable, as well as the master who has appointed the servant will be held liable. Here the difference, here there is a difference. What is the difference? There is a difference that who has appointed and who was appointed. Here in this case, who was appointed? Servant was appointed. And who has appointed? The master has appointed servant to do a particular job, but the servant has not done that particular work, or servant has committed wrong while doing that particular job. Then master will be held liable as if he was only doing that particular job. This is the meaning of the legal maxim Qui Facit per Alium Facit per se. Let's take some examples so that your concept will be clearer. For first example, if a master gives some work to the servant, like in case that I have given earlier, that if master has given some work to his servant to do that particular job, and the servant is doing that particular job, so in this case master is doing his job through another. He is doing that particular job through his servant. He has appointed that servant to do that particular job that he is responsible, he is obliged to perform that. Okay, another example is that A, the master ordered D. A is the master and D is the servant. A has ordered D, his servant, to complete the unfinished work. A has ordered D to finish the incomplete work or unfinished work. But in this case, what happened? In this case, D failed to do that particular job or work. A is ultimately held liable as though he failed to do so. Like we have just studied in the meaning of this legal maxim, that A will be held liable for any work or any omission done by his servant in his absence. So here also, in this example also, A will be held liable as D has not completed that unfinished work as ordered by A, the master. Okay, I hope the concept is clearer, and if it is clear, then please like, subscribe and share this video more so that you will get more such videos. And if you have any doubt relating to this video, please do comment, and stay safe. Thank you.